for lawyers in light of this new development?
Thank you. I think it goes without saying that whatever you are doing without professional training, no matter how well it is not well. It is not well to the extent that what taxation has become a profession. And because it is a profession, every lawyer that will want to be involved in the process of that tax system must also be properly trained. I have always said that anybody that thinks that he will read tax laws ordinarily and understand how it operates and works because he's a lawyer is making a very big mistake. I read a piece where Lodeni had made an argument that taxes, like I said earlier, are based either on the rate. And he said the rate that is going to be the foundation of taxes must be on the income of the taxpayer, not on his expenditure. Whatever is an expenditure of a taxpayer should not be taxed, because if you kill the plant, the fruit will also die. And therefore he made an argument that what is the legal understanding of income? And say ordinarily, the understanding of the average lawyer is an income is the balance you have after deducting your input from your output. And say that is perfect. You can define income in that way. But if that is the definition of income, the IRS and the NRS should go and start taxing armed robbers. Why? Because he said he has earned an income. He did an investment, and in the investment he put effort, and in the effort he made income. And therefore, if the ordinary definition of income is income, then the taxpayer must also visit an armed robber. And he said the ordinary argument that you can make against that is that the armed robber is, and he asked a legitimate question, which business is legitimate? Because most of the times before you can make additional profit from your income, you have to add one and one. You bought a property for 5 naira. Somebody is desperately in need of it, and you sell it for 1 million. Have you done anything wrong? No, then he said, no, that is business. But to the ordinary lawyer, that is illegal. And so you will always discover that knowledge of the system is very critical in understanding the workings of the system. And that also gives me very serious concern. It means we have not even appreciated the importance of what we are doing here. I mean, one local government is not enough to make what we have in this hall. And it tells you the importance that the lawyers have attached to this process. Therefore, it means that we are not professionalizing taxation. But whether we like it or not, like somebody argued in the morning, taxation is the future of Nigeria. Because gone are those days where people will ordinarily go to pay taxes without asking questions. We in the tax system had always said, and I tell every tax administration that I have opportunity of telling, that the difference between an armed robber and a tax administration is the law. They are doing the same thing, except that one is supported by the law, the other one is not supported. And therefore, the responsibility of a lawyer who is going to be involved in that is to know how the system works legally, not illegally. Thank you very much.
Thank you very much, Prof. Leonard Silksa. So, Prof has mentioned, has touched heavily on the knowledge, and as a practitioner that interfaces with tax lawyers often and often, which particular knowledge framework, to put it like that, would you recommend the NBA or NBA-SBL for lawyers, so we can be up to date? And you know, there's in our introductory speech, she mentioned these new laws, and then in the previous session, there was touch on the effective tax rate aligning with the OECD Pillar 1 and 2. So there's a lot to unpack with our laws in interaction with international treaties. So with this, what would you recommend for the NBA, NBA-SBL to do in bringing lawyers up to skill to solve these problems?
Thank you very much. Like Prof said, the importance of continuing education cannot be overemphasized. It is very, very important that even professors is still reading, I'm sure. So you can imagine some of us who are not professors, even senior advocates are still reading, your principals, the attorney generals, we are all still reading. So the essence of continuing our education in this regard cannot be overemphasized. A particular model, I know as a fact that the MBA has organized a lot of workshops, a lot of seminars to sensitize various lawyers. I don't know how much, but I'm sure even at the various branches, people have tried to have this stakeholder engagement to sensitize lawyers, most importantly, because of the critical role that we play in the effective implementation. If you don't read, if you don't compare what is obtainable in this regime with other regimes, or read existing legislations or prior legislations to find out what innovations has been brought into the new regime, your first reaction to it is to resist it and to tell your clients to resist. I remember before this law took effect this year, a lot of people everywhere you go to, whether in your church or your places of worship or in your community, people are asking you, how do we survive this legislation? Because a lot of people have not even sat down to read it. I know, as a matter of fact, in my own firm, we had to create a unit and we said, please come up with key points and key innovations of this legislation so that we all can easily read. It's quite a bulky legislation. So the education starts first with us reading and understanding what the legislation and the new reforms, because a lot of lawyers have not even read the legislation. Whatever we say are just what we have heard other people say. And then there are articles that have been written. So even if you cannot read on your own and understand, you take advantage of these articles. I've seen a few books also and pamphlets that have been written. But most importantly, please take advantage of the platform MBA provides. And then some institutions also have started offering refresher courses on these legislations. But most above all is the importance that the education starts with us first, reading and understanding what these new laws are all about and the reforms that has been introduced by this important legislation.
Thank you very much. I mean, I know there is a whole lot to unpack. And then to our NRS person, please just help us quickly touch on the innovations in these new tax laws. Piggyback on what you have said.
Hello.
I think we might.
Thank you. The key innovations. Hello. The key innovations in this new tax law is that we have the benchmark for payment of taxes. Hitherto, everybody who operates a company pays 30% income tax. But now, we have a threshold. If your turnover is not up to 100 million, and you don't have assets of 250 million, you don't pay tax. It does not stop there. For us to know that you are within this threshold, you have to have documentation. So, as lawyers who renders advice to our clients on businesses or commercial transactions, so please let us take time to go through these laws. So ignorance of the law is not an excuse. And VAT, hitherto companies that import and their businesses is not a bartable business. They don't have a way to recoup the imports, the input tax. But now you can apply for it and get the credits. Also, as individuals, if your income is below the minimum tax, you don't pay tax. If you are a businessman like a sole proprietor like most of us, law firm, maybe you are in a law firm or you have your own business. If your income, technically, if it's not up to 1 million, after deducting all your expenses, just like Prof said, that tax has a base and rates. And we have a progressive tax system in Nigeria. So if you don't earn more, you pay little. Companies of less than 100 million, like I said, you don't pay tax, but you must have the documents to support your position. So you cannot just say, I don't earn, my turnover is not up to 100 million. or my income is not up to 1 million after removing the relief, because you have a relief for your rent relief in a year. So technically 100 million, 1 million as an individual, you will not pay tax. But you must have document to show all your expenses, expenditures to arrive at that company, your that profit, your bank statements, and all of this stuff. Also now, if you are operating in agricultural sector, for the first 5 years, you don't pay tax.
Wow.
Yes.
Great.
You don't pay tax for the first 5 years. You have that benefit. Also, we have segmented the tax regime now. If you want to go into a new business, you can. If you don't know anything about it, you can write a letter to the tax authority to give you an advice. They give you an advance ruling on what are the implications of the business you are going into. What are the business, the tax implications, and you'll be rightly advised. Not only that, we have agricultural produce, pharmaceutical, all these things, they are not taxable. Medicals. But the problem with most of us is that we didn't go through these tax laws. So we just raised complaint that the tax law is going to tax, no, as the president has said, this tax laws is not going to tax us into poverty. It is going to tax profits. And it's only people that made profits that are going to pay taxes. So if you earn more, it's a progressive tax system. It's the more you earn, the more you pay. But you must be able to have documentation for all these processes. Also, we have digitalized all our processes now. You file your self-assessment online. You pay tax online. You get your e-receipts online. If you have done business with an organization or MDAs and they have deducted withholding tax, you got your credits online. So all these are seamless now. You don't need to be going from one office to the other. But you must be well informed. Information is key. If you don't have the right information, you fall into wrong hand. You don't need, it's very easy. Read letters as lawyers. It's very, very important for us to get ourselves accustomed to these new laws so that we can be well equipped to advise our clients and for us to implement it as well. God forbid that a lawyer will now be taken into the box to be charged for non-compliance with the tax laws. So I'm advising all of us to please let us accustom ourselves with the tax law. So, so we have a fiscal stabilization now with the new tax laws. So that is what it has stabilized the classes of production. Contracts no longer apply to income tax that are below 100 million, like I've said, turnover. Then VAT, stamp duties, they have segmented this. Now, even in this tax law now, the states and the local governments, they get the bulk of the VAT. So those are some of the novelties that we can see in these new tax laws.
Yes.
Thank you.
Yes, thank you very much. So, I mean, it's clear.
Is quiet, my neighbor's own is not quiet. Well, that is not as easy as even discovering that the person on top of you, his own generator is leaking fuel. Because it's not exposing him to the danger, it's exposing the person under danger. And that is why we are commending the new tax reform. It's the best and the most important thing that will happen to Nigeria. Because it has made our tax system clear, clean, practical, and measurable. You can now see how much you are expected to pay as tax, and nobody can visit you. Just take a simple example. If you are doing business in Nigeria, the local government will visit you, the state government will visit you, the federal government will visit you. All of them are coming under the provisions of law because we have all sorts of nuisance taxes. You will have bicycle tax, you will have wheelbarrow tax, you will have. So you ask yourself, how much is a wheelbarrow? that you will even start paying taxes on them. So what this new tax law, one of the best innovations that it has done is it has done away with all these new taxes and now concentrate on the very important taxes that can move the economic development of this country. Thank you.
Thank you very much, Prof. So our taxes are very much streamlined, but it's important that documentation remains king.
Yes, documentation is key. Because
key.
if you don't have knowledge, you cannot be able to pass the right information.
Yeah.
And is a lot of taxes that were hitherto enforced, they are no longer applicable, just like Prof said.
Yeah.
So it's a very good development, and it's going to strive our business environment and leads to economic prosperity in Nigeria.
Yeah, thank you very much. So it's a welcome development, as we can see from the room. So to FCTIRS, I would like to ask, now on the VAT, there's been a lot of issues about, I drink alcohol in the South, you get VAT that is shared across the country, right? So I would like to ask, briefly explain the 60% VAT allocation to states and how it is linked to consumption.
Okay, thank you. Well, before I will answer this question, I would like to make a comment on what Prof said and what the director said. For what Prof has said, that the objective of this tax reform is to make it clear and unambiguous for taxpayers to know what and what to pay and what is their tax obligation. And the taxes that they're supposed to pay, supposed to be in those tax laws. If you have read the tax laws, particularly Nigerian Tax Act and the Nigerian Tax Administration Act, any law that is not there, that is the initial objective. That tax is not taxable in Nigeria. But actually, this is my own personal opinion, not FCTRS or the chairman. So the aim is about to be defeated. Actually, if you look at the guideline for harmonization sent by GRB to State Internal Revenue Service, there are about 50 more new taxes in those. If you look at any of the harmonization laws passed by State Administration, there are about 50 new taxes collectible by the states and local government revenue committees. So actually, the new tax law create a gap. There is supposed to be that the taxes that should be collected by the state and the local government revenue committee supposed to be stated in that law. But if you look at the section 92, it just established the local government revenue committee, and they say they are the one responsible for collecting levies within the local government, but they have not specified the taxes. So now they are hiding under that provision to create more taxes. If you go to all of the states and local government, you will hardly see any difference before the act and now. They are still collecting what they have been collecting before because they come under the cover of a GRB. So then what I just say, all those tax incentives that she has said, actually, they are applicable to companies, not to individuals. In individuals, there is no threshold. Even if your chargeable income is 1 million naira, 2 million naira, it's still taxable. All these incentives are applicable to companies. Then for the question that you have asked me with respect to, I think it's 55, based on the provision of section 81 of the Nigerian Tax Administration Act, the allocation for states is now 55%. Previously, it is 50%. So now, because the federal government allocation, it was reduced from 15% to 10%. But actually, this has no link with the actual consumption. You know, they have two formulas for sharing the revenue. They have vertical formula and they have horizontal formula. The vertical formula is how the revenue is shared among the tiers of government. So if you look at the federal government is collecting only 10% as a cost of collection, because by the virtue of the Nigerian Constitution, the consumption tax is not within the exclusive or concurrent list. So it's supposed to be under the jurisdiction of the state internal revenue service. Well, due to efficiency an operational possibility. The federal government is collecting the tax on their behalf and giving it to them. But where the consumption is linked to what they collected is based on the vertical formula when they are sharing the revenue among the state. If, for instance, after 55% of the VAT collection was shared to the state or was distributed to the state, when they are distributing that among them, so that's what the consumption is linked, because they share it in three categories. First, 50% is based on equality, 20% based on population, and 30% based on consumption. And the consumption tax is based on destination principle, where the consumption took place. Even before, even expert taxation, sometimes they are making mistake of mixing the concept of remittance and derivation, particularly for VAT. That is one of the things that is causing a lot of tension when they are talking about distribution of VAT revenue. Because consumption tax is derived, the revenue is derived where the consumption took place, not where it has been remitted. But you know, FRS, they have their own system. They allow companies to make a central filing, remittances. For instance now, Dangote, the headquarters of Dangote is in Lagos. So, but the Dangote product is consumed almost all over Nigeria. But the VAT is remitted by Dangote in Lagos. So for people who start telling you that the VAT derivation is 60% from Lagos, which is not true. It's the remittance from Lagos. But the derivation is derived throughout the country, not that. So some people are mixing the two concepts. But actually, that horizontal formula sharing is not linked to consumption. It's linked to rights of the VAT collection. It's only the horizontal formula that is partially linked to consumption. That is 30% of it. Thank you.
All right, thank you very much. Leonard Tick has something to add.
Just a moment. What I want to say is that VAT is a consumption tax. All over the world is a transactional tax. It is based on the capacity, and it applies to all over Nigeria. So the law is a national law. And what is happening is that the NRS collects it on behalf of all the nation. Because of this dichotomy. Because if somebody is in Lagos, in Kafancha, in Port Harcourt, and they will not be able to collect it, but FRS is in all the states of the Federation. So that is why FRS collects it on behalf of all the subnational. And it collects it. It doesn't take 10% as cost of collection. You understand? That is the allocation that is given to the federal. You understand? FRA does not take 10%. Please, I enjoin you all to take out time to read the laws. There is no way it is stated that NRS take 10% as cost of collection. It's
for the federal government.
So it's the federal government. The bulk of it is shared to the states and the local government. Thank you.
All right, great. Leonard Tick as Prof.
I just wanted to add, because I want to agree with the learned senior advocate, that knowledge-driven steps is the only one that will lead you to the promised land. Just like he said that the lawyers will need to update themselves on the knowledge of the law, I also want to say that tax administrators must also do the same thing, because they should not assume that they are already familiar with the working system of the law and continue with what they were doing before. This law has done a turnaround. It is a U-turn that it has done from our earlier arrangement. I have read King Lubengula, the king of Susu. He had always argued that the prayer he needed from his people is, may his road be rough. This is how they greet him in his palace. May your road be rough. And his argument is, if your road had been very rough, the day you get a smooth road, nobody can see your back. Yeah. Now, the tax administrations will have been given a clean road now. But if they continue with the drive that they had been using, it will not take us anywhere. This argument that VAT is not on the exclusive list, it's not a concurrent, it's not anywhere to be found. if you allow the state to manage the affairs of collecting VAT, they will never be able to collect anything.
Yeah.
It is the federal government that has the capacity and the capability to be able to collect. And what do you need? It has even been increased from 50% to 60%. And therefore, it is very important that they understand that the working system is for the benefit of all, and the taxpayers will take maximum benefit. It is important to note that the new law had introduced something that is very small, but is very critical. It has moved from the way of VAT exemption to 0% allocation. Now, there is a clear difference between exempting somebody and giving him a percentage, even if that percentage is 0. Because 0 is also a figure. Thank you very much.
Thank you very much, Prof. All right, Leonard, take.
Okay. Thank you very much. By way of observation, I wanted to add a few things to what Prof said earlier, and he added another new thing. I don't know where you practice or where you live, but for some of you who came from Abuja, one of the very significant essence of this new tax administration is to harmonize all existing legislations so that you create a one-stop shop, one-stop legislations that will regulate the tax administration. Now, the whole idea is so that you don't wake up one day and you're receiving invoices or demand notices from local governments, from state governments and the likes, like Prof. Riley stated. But in Abuja, as we speak, despite the passage of the act and the harmonization, it looks like the passage has awoken the area councils. Because more than ever, practitioners in Abuja, whether law firms or businesses, our clients, as various SMEs, are receiving various tax demand notices. I've had to personally call somebody in the FCTIRS who I told him, I said, see what's happening. They said it's a problem that they have seen. So that brings us back to the role, like I said earlier, the role of legal practitioners. It is not only the private legal practitioners who have a role to play in ensuring compliance. Even the in-house lawyers in the public sector. It looks like somewhere, somehow, somebody has to do something. Somebody has to educate. Like Prof said, even the taxpayers need to read this law and understand, because it looks like the people at the local government do not understand what harmonization is all about. Thank you very much.
Yeah, thank you very much. I mean, we can go on and on and on, but please, we are opening the floor now to the audience. If there's any question, now is the time, please. The mic. We have a question. We have a question. And please, because lunchtime is fast approaching, or even here already, and we still have to go back to our hotels. Just 2 questions. So after we'll take just one more, please. Is there another one? Okay, I can see. All right, thank you. Then you. Thank you. 2 more. 3. Okay, 3. All right.
Okay. My name is Adele Morocco Club. A couple of questions, please. And the first question is with regards to, we've been told that the start date for the new tax act was January 2026. But then we also have instructions saying people needed to file their self-assessment personal tax returns by the 31st of March. And I'm like, if the tax act just took effect, is it not next year we're supposed to be filing the returns? That's the first one. The second, okay. I had a few questions, but I'll just quickly ask the second question. The second question is that, with regards to withholding tax, for example, if a person has, like, let's say me, an employee, pay as you earn has been deducted by the tax, by my employers, and then I have another income in which there has been
outside your employment.
Yes, and so withholding tax has also been deducted there. Can the tax authorities to me and say, actually, that 10% is not enough, you need to pay more? Or in a situation where my income is little or very little, can they refund me the 10% because I have not hit the threshold? Do you understand? Thank you.
So I think I would like the first question. Yes, Madam, please take it. And second question related to individuals. So FCTIRS, you could take that. Thank you.
Thank Thank you very much, madam. On the issue of the tax
Effective
law, applicable dates, the tax laws were passed into law in June 2025. And in line with the national tax policy, and to give room for people to prepare their affairs, to get used to it, the government said it will take effect from January 2026. However, we all know that in taxation, we have what is called transactional tax. And taxes like income tax and that is paid on a preceding year basis. For income tax, you do your business in a year, then you pay your tax the following year. So that is the law. The law is that you do your business in 1 year and you pay your tax the following year. So that's the fact that it comes into effect in year 2026 January does not preclude you, because it is the law that is applicable. When the duty to pay tax arises, that is the law that you will be that you be liable to.
Oh, okay, yeah.
You understand me? It's the law that is applicable.
Yes.
On the year that you have that duty to pay the tax, that's the law that will be applicable to you.
Yes,
But
you.
in case of stamp duties and VAT, if you do transaction in this month, the law says you are going to render returns in the next month, 21st of March. That is what the law says. It is very clear. So if you do business for December, the duty to pay is already in that December, because when you are buying your pen, they deducted the VAT. They don't wait till next year. When you are buying whatever, it has been deducted. So you are only remitting it the following year. So the applicable rate, a date for the transactional tax is when the transaction was done, while for income tax, it is the year of assessment, and when that year of assessment comes, is the law in place that will be applicable. Do you understand me? So that is why for businesses done in 2025, if you are filing in 2026, it is the law that is enforced today that you will be liable to. So, and some people are filed in 2026. They now said their threshold is below 100 million. They filed new returns. But in 2025, they were liable to pay tax. Okay. So that is the beauty of it. Thank you.
Okay, great. So the second question.
Please, I didn't get the question about withholding tax.
So
Okay.
Okay, so I think the question was on if she has an income outside her employment income, and then her employer has already withheld the right and paid tax on that, right? Out the income she makes outside her employment, will
Okay.
you still tax it?
Okay, well, if you are seeing, based on the provision of the section 28 of the Nigerian Tax Administration Act, every taxpayer is expected to make a related filing to declare all of income. So I guess what we are doing, and that's what the law is saying, is that if you declare all your sources of income, and you are one of the sources of income, one of your sources of income is employment, maybe already from a payee remittances, maybe already 1 million naira has already been remitted to the relevant tax authority. And now, based on your consolidated filing, after you have declared all your sources of income, the tax that you're supposed to pay is 1.1 million naira. So that payee that has already been remitted has to be offset against that 1.1 million naira. So what you are going to pay is that only 100,000.
All right, thank you. So the next question.
What he's saying is that you are in an employment income. You pay your income was taxes was deducted from your employment income. So if you have another business that you are doing and you earn income, you have to declare it, and then there will be a consequential taxes arising from the profits you made from that income. That is the law.
All right, so
Let me just add one thing. I'm sorry. You see, withholding tax is not a tax.
It's a mechanism.
It is just an opportunity that the tax administration is given to keep some part of your resources such that when it is about for you to pay the tax, they can use the resources and do hard or drop. If what they have withheld is up to the threshold of what you're supposed to pay as tax and is equal to it, balanced, nobody will ask you. If what they have withheld is more than what you are supposed to pay as tax, you are entitled to some returns. If what they have withheld is what they have collected, then you will pay the balance. The tax is based on the returns that you make. That is why it is said by the provisions of the Nigerian Tax Act that the basis of every tax assessment is the returns that you have made. And you know we are operating self-assessment process. You are supposed to, in your room, calculate how much is expected. Both the one that has been withheld and the ones that you make outside the employment, calculate everything and go to the bank, pay your money and take the receipt to the tax administration.
Yes.
Now, if you are making the returns, you are supposed to take cognizance of the with all taxes that they have made. Then you put it in what you have collected, and if you are entitled to refund, ask for refund. Normally what they do, they may not give you cash, but they may give you a tax credit.
All right, great. Thank you very much. The next question.
Thank you. Is it okay? Yes. I have only one question. My question is, what is the role of tax administrators in government MDAs? I ask this because recently one of the tax administrators came to our ministry. By the way, I am Iswake Misali, the Solicitor General, Adamawa State Ministry of Justice. The officer said he wants bank statement of account for 6 years of the ministry. Thank you.
Yes, ma'am. Yes, ma'am.
The MDAs have authority, they have to deduct the taxes of their personnel and remit it to the relevant tax authorities. That's number one. Number two, if an MDA gives contracts out, they have a duty to withhold 5% before paying over the contract sum to the contractor. And they have a duty to also pay VAT on their consumables. So if they have come, they want to see whether you have complied with all the provisions of these tax laws. And under the new tax laws, now we have series of cases with the MDAs and state governments. State government award contracts, they don't withhold tax. The 5% is supposed to withhold, because most of these companies, they are portfolio companies. They are just incorporated to get business from their political or friends. So they take the business, take the contract and go away. So that is why the government has this withholding tax in place. It is this withholding tax that will let the tax authority know that you have done a business with the states. You understand me? So the states and MDAs, they have the duty to withhold the taxes and to pay taxes of their personnel and withholding tax. And it's in the law. If a state authority fails to do that, they are in breach of the laws. And in these new laws now, the Accountant General of the Federation has the power to deduct at source these unremitted taxes.
Okay.
Thank you.
Let me add to what she just said. You said you are Solicitor General. Okay. I used to be your colleague. I served here as Solicitor General some years back. I served for over 6.5 years or so here in Kaduna. Now it depends on the payment platform your state is using. In Kaduna here, the platform is payment of salaries is consolidated, and that's from the head of service and Accountant General of the state, and payment of contractors also is centralized. So what you have MDAs do is that when I was Solicitor General, we didn't pay salaries. Yes, the provision is provided in our budget, but the actual payment of salary is not done or regulated by the permanent secretary of that ministry. The same thing with contractors. Even if the contractors were ours or the service was rendered to us, the payment was done by the accountant general, so it was centralized. So if that is the case in your state, you may just direct them accordingly. So that would not be primarily your responsibility. But if you maintain the old way of doing things, which is where individuals, ministries pay salaries, then you have to deduct and remit as she said.
Sorry,
All right,
you
that's
see,
great. So
you
we
also
have-
have, sorry, just 2 minutes. You also have a responsibility to give your staff tax clearance. And you will not be able to give these tax clearances if you don't know how much has been deducted as taxes. So like he said, if you are not responsible, you are entitled to all the information that you require. And it's very clear that the Tax Administration Act has made provision that tax liabilities will stay alive for 6 years, even if you are not at fault. You didn't commit any wrong, you were not fraudulent in not being able to pay your taxes. If it is discovered within 6 years, you will still have to pay. That is why he came by and said he wanted to see for 6 years. If you are at fault, the law says it is ad infinitum. Even if it is 100 years that it was discovered that you were supposed to have paid the tax and you fraudulently refuse to pay, you must pay. But where you were not at fault, the law has limited the threshold period to 6 years. That was why I was asking for 6 years information. Thank you.
Okay.
Okay,
So
and the
before
final
lights
question,
finally goes
please.
up. Final question.
Good afternoon. My name is Nasuru Shinkafi. I don't know the speaker that said it, but what I heard, somebody said in northern Nigeria, we are taxing poverty. Okay, the prof, okay. Maybe I'll direct it to him. Now, if we look at section 24, so 4 of Nigerian Tax Administration Act, there are some incentives provided for companies and individuals. For individual, for example, anybody that earns 800,000 per annum is exempted. That is one. Now, number 2, for companies whose turnover is 100 million or less, or they have an asset of 250 million, they are exempt income tax, CGT, that is capital gains tax and development levy. They are all exempted. Now, number 3, VAT, the value added tax. If we look at it, the prorated list has been expanded. There is food. Initially, we have basic food items, but food is included, books, medicals. And if we look at the input VAT for services rendered, they are fully claimable. Then when we look at stamp duties too, initially, stamp duties is charged maybe 1% or 1.5%, as the case may be. But now it has been reduced to 1,000 naira per transactions, or any transaction that is less than or 1 million or less is exempted. So I want to know what is poverty in all these things. Thank you very much.
So can I just react?
Yes, quickly, please.
You see, what we are saying is, before the new tax legislation came on board, the provisions of the law, especially in relation to Peter, is that you pay as you earn. Which means by necessary interpretation, if you earn 1 naira, you will pay based on 1 naira that you have earned. Now, one of the very beautiful innovations that this new legislation has introduced is it has provided a threshold, just like you said. If your earning annually is less than 800,000 naira, you are not paying a dime, which means that if you are within the struggling age, you are not paying anything. That is why we said it is one of the beautiful innovations that this new tax law has introduced. The same thing with SMEs. Companies that have been proprieted by people who are struggling to establish a business have also been exempted from tax payment, which means that if your investment is less than 100 million naira, you are not paying anything. That is why we said before now we were taxing poverty, but the new law has moved on. People who must pay tax must be people who have actually been able to establish their business. You have tax holiday before you are able to establish your tax business. So if I say we were taxing poverty, it means the old generation, every provision of Peter is taxing payee. which means pay as you earn.
All right.
Which means they were not cognizant of how much you are earning. But this new law has actually give a threshold of how much you must have to earn before you can be taxed.
Yes, impressive. So thank you very much, distinguished panelists. We've had quite an engaging session. I think we'll just wrap it up with final takes from everyone.
10 seconds, please, each.
Yes, 10 seconds each. And then in your final take from the FCTIRS, and please kindly touch on one thing she mentioned in her question, the first question, on when you should file for income tax. So she kind of, I think we left that out in answering the question. And then SAN, sir, you can also in your final take touch on what are the opportunities for lawyers specifically under the new regime. So we start from Prof and take it down. Very quickly, please.
Well, I think my own call will be to the organizers of this program. It is important, like the Learned Senior Advocate has said, that the only thing that the lawyers have different from non-lawyers is the knowledge of the law. And most of the times you don't get this knowledge unless, of course, you are committed to the process. I am terribly disappointed at the attendance of this program. And therefore, I call on the organizers that they should find a way of making lawyers to participate in some of these programs because there is something to learn. If you are doing a professional responsibility, you should be a professional. Thank you.
Yes, ma'am.
Thank you very much. My party words is that I want us to know that taxation is the reward you pay for doing well as an individual or a company. That's the reward you pay. In all our statutes, our laws, it's you only pay tax if you are doing well. And with this taxation we are paying, it's a form of redistribution of wealth, and it gives the governments opportunities to give basic infrastructures and amenities to the nation. So with this taxation we are paying, together we are building the nation. We are building a nation to make our nation a formidable place. Because all this Western world that we are seeing, it is taxation that they are using to develop their nation. And when we pay this tax rightly, we will have the right to question how this money is being spent. Thank you very much.
Fantastic. Yes, sir.
One important thing that I want to highlight, particularly for lawyers, that is important to inform their clients, is one of the objectives of this tax reform is to encourage formalization so that to discourage doing business informally. That's why in the provision of the tax laws, if you are doing a business as a limited liability company, if your income is not up to annual income, is not up to 100 million naira, you are exempted from paying taxes. But if you are doing a business as an individual, you are not exempted because they want to push people to formalize. Because you can see this is your neighbor, he's registered as a limited liability company, his turnover is more than yours, but he's paying nothing as tax. But you there, you are not formalized, you don't have any registration, you are still paying taxes. That will encourage you to go and register. So it is important for lawyers to inform their clients, to even advise them on the form of formalization they're supposed to embark as a tax planning process. With respect to filing, for individuals, even if you are in employment or you are in business, if you are in employment already, your employer is filing monthly returns for you. This is the employer's filing. But you as an individual, you have to file your returns on or before 31st March of every year following the year on which those economic activities occurred. So the filing is within 90 days from 1st of January. That is usually 31st March is the due date. But most of the transnational, they have extended the filing periods.
Thank you, sir.
Besides, can you hear me?
Yes, yes.
Okay, besides our perceived traditional role of challenging bills sent to our clients. There are quite a lot of opportunities out there by virtue of this new tax regime. One of them is, number one, you will agree with me that all of us are potential, by our training, all of us are potential compliance officers, meaning people out there perceive us to know the law and how to move around it. So if you know the law very well in this regard, there are quite a lot of opportunities for you in respect of ensuring compliance. That's number one. Number two, there's also the training component of it. Sometimes last year I was invited to Kano to speak at a function organized by the Ariwa Committee of IRS. I met your chairman there. So you see, to the extent that you know the provisions of this law, people will consult you and invite you to partake, to either train them or partake in various training across. Now, in 2016, I was part of the team, or I led the team that drafted the Kaduna State law, the tax law, which later became a model for many states, and which is not so different from what was passed now. One opportunity that I saw very well there was the conversations we had with various private sector people who will come either trying to act as consultants or the introduction of technology. So there are quite a lot of agreements that we'll have to sign. The law is one thing, but the law cannot implement itself. They have to introduce various technologies at various, and in the purchase of these technologies or the introduction of these technologies lies agreements that will be written. So if you put your ears on the ground, you may be consulted to draft this very important and then it's a continuous process. They will just have to keep, there's no perfect legislation. They have passed this one, they passed it. When we passed the one in Kaduna in 2016, shortly thereafter, it had to be reviewed. So you need to constantly review this, and to the extent that you know this law, various state governments or houses of assembly, you will serve as consultants to the various houses of assembly or to the various committees. So there are quite a lot of opportunities out there. Thank you very much.
All right, thank you very much, ladies and gentlemen. With that, we've come to the end of the session. Please, a beautiful round of applause for yourself and for the panelists. Thank you.
Okay. Moving on, we would have a quick presentation for our lovely speakers today. We thank you for the insightful session. We'll be beginning with Chris Umar SAN, the managing partner of Chris Umar SAN & Co.
And while that is going on, I'm sure you will notice a very beautiful flyer on the stage. The second NBA-SBL Northern Zonal Conference Committee invites you to a dinner party tonight happening here.
Dr. Al-Hassan Usman, representing Mr. Michael Ango, the acting executive chairman of FCTIRS. Bolanle Hajaranu Yongi, the Director of Litigation and Prosecution for the NRS. Next up, Professor Abdulmumini Bala Ahmed, Professor of Law, Bayero University, Kano. And finally, our moderator, Musa Kalejaye, Associate Duale Ovia and Alex Adedipe.
And finally, we have our able session manager, Ehumazino Otiorimo. I hope I didn't murder your name.
Okay, so we'll be back here this evening by 6:30 p.m. prompt. 6:30 p.m. prompt. Please, they're here already. Okay, so we'll have a quick group photograph. And while we're enjoying this lunch, please let's remember that I'll be back here by 6:30 p.m. prompt For the dinner party, the theme is Threads of Heritage, Weaving Culture, Policy, and Progress. And the dress code is African Heritage or Smart Elegant. Please come in on time, come in gorgeously dressed. Okay, please take note that there's a separate setup for the VIP and the speakers. So please, for the lunch, there's a separate setup for the lunch for the VIP and the speakers. So please, the protocol should ensure that there's an orderly progress to the lunch, please. Please, let's come in on time, 6:30 p.m. for our dinner party. Thank you very much. I do hope you've had a wonderful time today. We'll meet again in the evening, then tomorrow for the other sessions. Thank you very much, and see you by 6:30 p.m.